Jenny will now take you through more of the legal details associated with PRAs.
Thanks, Scott. It's, I think what you make clear is that it's a massive undertaking to comply with the PRA, and it obviously requires these very sophisticated procedures that we have in place for such a large organization with so many public records to comply. Why is that so critical? I'm going to talk just a little bit about a couple of key points under the PRA. We're not going to do an exhaustive overview of the PRA the way we did on Bagley-Keene. There's just a few things I want to highlight. First, I want to talk about the purpose, which I think really supports the points that Scott has risen. The purpose of the PRA, like Bagley-Keene, is to facilitate public involvement in government, and specifically the public's right to monitor government. One of the things that's interesting about the PRA's purpose that's a little different is that in 2004, Prop 59 added a section to the state constitution, which essentially provides that statutes like the PRA must be construed broadly to further the people's right of access to government. So you have this very compelling, strong public policy expressed not just in the law itself, but in the Constitution of the state that supports construing this law in favor of access. So but very briefly, let's talk about what a public record is. A public record can be any writing at all. The medium really is irrelevant. Anything under the sun can be considered a public record, basically. A recent case said that every conceivable kind of record is a record. So it might be electronic, it might be voice, a voicemail, a text, an email, a photograph. It doesn't have to be
Let's make sure we PRA this.
a phone call. You may be familiar with a recent case, Smith versus City of San Jose. This was a very interesting case because the court found that text messages between the public officials on their own personal devices were public records. This case is on appeal, but I think it really highlights the universe that we're in and the direction that we're in. As it becomes less, the lines between your personal life and your public servant life become more and more blurred by virtue of the fact that there's so many ways to communicate. You don't have to come into your office and sit down at your office computer to communicate. As those lines become more and more blurred, the potential for public records on something that might otherwise feel private to you increases. They're really,
I got
yes.
a question. So I find the San Jose case actually fairly fascinating. We dealt with this issue several years ago when we were in the governor's office because it's not so much the median, it's the content of the message. Okay, so whether you manage 2 email systems, 3 email systems, so sort of 2 questions I have is, one is, how long do you have to retain the record? So if there's a custom and practice, that you purge your emails every so often. So, I mean, can we discuss or at least tell us a little about that? And the other is, goes back to this whole median argument, is if I'm using my calPERS email and I switch to a Gmail account, then the question then opens, as we were talking yesterday with Robert's folks, as we move more into social media, what's covered? I mean, even from the subject of Twitter or Facebook, how far would the PRA cover into that? So if I'm friends with JJ, okay, or Slayton, suddenly 3 of us are commenting on the great photo of my kids. We now have 3. It's not within the course of business, but what's reachable on that?
Good questions. I'm gonna address your second question first, and then let Gina comment on the retention question, your first question. What's interesting, I think, the point you made about in your second question is that really we end up talking about both a PRA issue and a Bagley-Keene issue in a situation like the text messages. So if you have a quorum of the body involved in those text messages or involved in emails that flow from a personal email address, you could have a meeting for the reasons that we've already discussed. And basically the way to think about it is it really doesn't matter whether it's coming from your personal email account or from your personal handheld device. That's basically irrelevant if the context of the members convening, coming together and communicating would otherwise be a meeting. And then the same would apply for whether you have a public record. It doesn't really matter if it is from a personal email account or from a personal device if the substance of that communication, that email, that text, otherwise results in a public record. So you're talking about something related to business. I think you also have asked, well, what point does the line cross? I mean, certainly your example of texting the picture to other board members is not going to result in a public record because it has nothing to do, presumably has nothing to do with business of the body you serve on. But if it is something where it does have to do with the body's business, then I think you have created a public record. Even if you don't have a meeting, you may have created a public record, depending on what that says.
Taking JJ's comment or suggestion, so you send a Wall Street Journal article around, or you post it outside of it. So you use a Gmail account, and you just say, interesting Wall Street article journal today on calPERS investment, because we bought something. Okay, you pop that out. Goes one is to the retention, back to the public record, and then, does that email itself constitute? Because again, there are two things. There's, do I retain it for purposes of a PRA? Because my comment is, fund got it wrong, type of thing, versus the Bagley Keene.
Yeah, I see what you're saying. Do you want to talk about the retention piece?
Yes, we do have a policy at calPERS about record retention and specifically about email retention. I don't know the number of days off the top of my head. It's 60 or 90 days where we keep emails, after which time, if they're not separately saved, they're destroyed and no longer available. I don't believe that we have looked at our policy in light of the City of San Jose case to think about whether or not that record retention policy or email retention policy would reach into your emails, for example, on your personal email address. Currently, they would not be covered under the policy, but I think we should probably take a look at it and see whether or not they should.
And certainly there's still a lot of gray. This case is on appeal, so I don't know that we have the hard and fast rule, but we see where the courts are headed. We see the direction we're going in, and it raises perhaps more questions than answers at this point, but I think our point is to sensitize ourselves to it and begin to think differently about things that might feel otherwise personal. Okay, I talked about this very, very quickly. I'm just going to highlight a few of the exemptions to the disclosure rule. As I think you all know, notes, drafts, and memos that are not retained in the ordinary course of business don't have to be disclosed under a Public Records Act request, provided that the public interest in non-disclosure outweighs the public interest in disclosure. Again, keep in mind you have a constitutional requirement to construe the statute in favor of public interest. So you really have to think about the public's interest. Litigation and attorney records, provided they're created after litigation has been commenced, those are generally not subject to a PRA request. Personal, medical, and similar records that are private, that exception is really, the purpose behind it is to protect the confidentiality of the individual as the subject of the record, as opposed to the public agency or the state agency. And then finally, briefly, I'll just mention the general public interest exemption and the deliberative process privilege. When a body has discussions with their advisors, or there's communications in writing with their advisor or in any kind of format with their advisors that are just deliberative, they don't support a final decision, those can be protected. But underlying facts or underlying documents that go to that final decision, they're not protected. And then the catch-all, what we call the catch-all exemption, is that there's a general balancing test that can be applied under the PRA, allowing the agency to withhold records from disclosure if it can establish that the public's interest in not having them disclosed outweighs disclosure.
Can you give an example of what would be deliberative versus leading to a facts or leading to a decision?
Sure.
I'm sure I understand.
So let's say that the body is presented with the scope of options that could be taken, the things that might happen, and there's a document. Do you want to do this? I'm drawing a blank.
Sure. This isn't an easy one, but so so let's say one of the staff members is working on a memo of some kind, and you have a series of drafts. There's no obligation to retain, not that there's no obligation, but in our ordinary course of business, we don't retain all of the prior generations of the memo before once the memo becomes final, we destroy all those. So even if, my typical practice would be to get rid of it 10 days after, and it's still sitting there, it's considered a draft. It's considered something that's not retained in the ordinary course of business. It would not be a record subject to the PRA.
Okay, but so you're saying that's part of that would be considered deliberative as opposed to leading to the decision?
That's right. So the idea in Gina's example is that those drafts that the staff person puts together along the way that are not reflected in the final draft are really deliberating what to ultimately conclude, what to ultimately say, and so those don't need to be kept.
Okay, so that's not real, okay. Okay, so for the board probably doesn't really even have deliberative, it would be a rare circumstance where there'd be a deliberative communication or.
Yeah, I can't think of any.
Okay.
Yeah, I think your question's interesting because as I'm listening to you, I'm thinking, you're thinking, but aren't our deliberations supposed to be public? And so you're right. I think to a large degree this exception would probably fly in the face of the other rules when it comes to the board's deliberations. Okay, so the last thing I was going to mention is on the catch-all exception for the PRA. Just a reminder, it's really the public's interest that allows us to withhold something. So it's not the state agency's interest in non-disclosure. The whole test goes to what's in the public's best interest. And so that's the consideration that we take in when we are considering whether to disclose something under the PRA. So with that, I'll open it to questions.
Thanks. Scott, you said that the average PRA response time is about 32 days. I imagine that's due to the complex ones kind of skewing it, but I wondered, do we have the flexibility if somebody requests through the online portal information that we already know is readily available? Do we have the flexibility to just get it out really quickly?
Yes, we do. And some PRAs are closed in a matter of an 8-hour business day. Often requests for data that we would never release, we simply tell them this is not disclosable, or we can point them to resources online where they can find it themselves.
Right. Thanks.
Yeah, on those items that are drafts before you lead up to a final document, while you say they're not under the Disclosure Act, but in a discovery from a legal issue, they can request those drafts?
Well, the litigation discovery rules kind of have a life of their own, and they probably would be discoverable in litigation. Again, provided some other privilege didn't apply to them.
Okay,
Well, seeing nobody else asking questions or any comments, I'd like to thank you all for a great presentation, for dry material. You did a good job. Thank you.